Welcome to This Explainer. Today, we're diving into a fascinating legal showdown that asks a genuinely terrifying question about your access to justice. We often think of constitutional law in terms of these grand ideals and sweeping declarations of human rights, right? But what actually happens when the very mechanics of the legal system threaten to totally bankrupt the everyday people trying to protect those rights? So I want you to imagine a total nightmare scenario. You're just an ordinary citizen. You sue the government because you firmly believe they violated your constitutional rights. You fight your way up through the courts, spending an unbelievable amount of time, energy, and of course money. You are literally right on the verge of a hearing at the highest court in the land, and suddenly, the government changes the law. Your entire case just evaporates into thin air. But the nightmare doesn't actually end there, because the government then turns around and demands that you pay their legal bills. What happens next? Honestly, would you ever dare to challenge the state again?
Section 1. The School Subsidy Dispute. To answer that terrifying question, we have to go back to the initial catalyst for this conflict. It's a classic David versus Goliath story, and it set off a major chain reaction in South African constitutional law.
Okay, let's dive right into this. The spark for this entire legal battle ignited back in October 1995. A group of parents, who were acting on behalf of what were then known as state-aided schools, took the Orange Free State Provincial Administration to court. Why? Well, because the government had suddenly made a decision that terminated vital financial support. We're talking specifically about bursaries and transport subsidies for the pupils attending those schools. For these parents, this wasn't just some minor administrative hiccup. This was an issue of massive, everyday importance for their children's education and their futures.
To really grasp how this bizarre sequence of events unfolded and eventually trapped these parents, we have to look at the timeline. This was definitely not a quick skirmish. Notice how it stretches over nearly 3 years of legal battles. It started with that initial lower court hearing in October 1995, wound its way through appeals, slammed into a massive legislative roadblock in early 1997, and then finally culminated in a landmark judgment in May 1998. It was a marathon.
Section 2. A mixed legal victory. So the parents took their fight to the Supreme Court's Orange Free State Provincial Division. And there, Judge Lombard handed down a ruling that was, quite frankly, a bit of a mixed bag.
Judge Lombard's split decision was super fascinating. On the one hand, the parents won a major victory. The judge granted a declaratory order, basically agreeing that the government's decision to terminate the subsidies violated the interim constitution. He even ordered the government to pay the applicants' costs for that specific hearing. But, and this is the crucial part, he denied consequential relief. He flat out refused to force the government to actually backpay those bursaries or formally reinstate them from the start of the 1995 school year.
You can imagine how frustrating that must have been. They won the big constitutional argument, but they didn't get the practical financial relief they desperately needed. So, understandably aggrieved, the parents decided they couldn't just stop there. They boldly applied for leave to appeal directly to the Constitutional Court. The president of the Constitutional Court issued directions, and a hearing date was officially set for March 11, 1997. They were heading to the absolute top.
Section 3. The case becomes moot. But just as they were preparing for their day in the highest court in the land, a massive legislative plot twist totally derailed the entire case. While the parents were gearing up for their big 1997 appeal, the national government passed a sweeping new law, the South African Schools Act 84 of 1996. And among its many provisions, this new law completely abolished the very concept of state-aided schools, with effect from January 1, 1997. Because the very category of schools they were fighting for was legally abolished, the case was instantly rendered moot. It had no practical significance anymore. I mean, you can't exactly ask a court to reinstate funding for a school type that no longer legally exists, right? Realizing their case was dead on arrival through absolutely no fault of their own, by the way, the parents had no choice but to formally withdraw their application for leave to appeal on December 23, 1996.
Section 4. The Battle Over Costs. Now, you'd think the story ends there, right? The law changed, the case was dropped, everybody just goes home. But no. A terrifying final threat emerged from the government, turning a dead case into a ridiculously high-stakes battle over access to justice itself.
See, when the parents withdrew their appeal, they didn't offer to pay the government's legal costs for the constitutional court preparations. And after some unsuccessful negotiations, the state attorney actually wrote to the registrar of the Constitutional Court in August 1997 with a really harsh demand. The government wanted the court to issue an order compelling these parents to foot the government's entire legal bill for the aborted appeal.
The absolute crucial point here is the chilling effect this creates. Just think about it for a second. If the government wins this demand, and everyday citizens are forced to pay the state's massively expensive legal fees just because a new law rendered their perfectly valid good faith case moot. Who would ever dare sue the state again? The sheer fear of bankruptcy would paralyze the average person from ever attempting to hold the government accountable for constitutional violations. It's a terrifying precedent.
Section 5. Protecting constitutional rights. This brings us to the climax in May 1998, when Justice Goldstone and the Constitutional Court had to step in and decide if these parents should be punished financially for a legislative change they had zero control over. Justice Goldstone swiftly and firmly rejected the government's demand for costs. He noted that the parents had acted entirely in good faith. He pointed out three key things: their complaints were not frivolous, the legal action wasn't vexatious, and there was absolutely no suggestion of improper motives. The withdrawal of those bursaries was an issue of huge importance to these parents, and they were simply trying to look out for their kids.
Now, Justice Goldstone made sure to be incredibly precise here. He clarified that sparing the parents from the legal bill was not an endorsement of their original claims for the money. The actual merits of their appeal were never argued before the Constitutional Court. But, as he rightly pointed out, it would be a massive waste of public money and judicial resources to force everyone to argue a dead, moot issue just to figure out who should pay the legal fees. The costs of doing that would heavily exceed the costs they'd already incurred. It just didn't make sense.
And this right here is the absolute mic drop moment of this explainer. This brings us to a foundational principle of South African law. Justice Goldstone wrote, and I quote, "Litigants should not be discouraged from enforcing their constitutional rights by having to run the risk of having to pay the costs of their governmental adversaries." That single sentence ensured that citizens who act in good faith to protect their rights shouldn't be terrified of financial ruin if they happen to lose, or in this weird case, if the rules of the game just completely change halfway through.
With that incredibly powerful foundational justification, the court officially handed down its final word on the matter. With regard to the application for leave to appeal, there is no order as to costs. Neither side had to pay the other. It was a massive win, not just for those specific parents in the Orange Free State, but honestly, for the very concept of access to justice for everyone.
As we wrap up this explainer, I really want you to consider this. It is super easy to write down rights on a piece of paper, but rights are only as strong as your ability to actually enforce them in the real world. If the legal system's financial penalties scare the little guy away from the courthouse, do those rights even exist at all? This case proves that true justice requires not just fair laws, but the actual freedom to challenge authority without the paralyzing fear of losing everything you own. Thank you so much for joining me today, and keep questioning how the systems around you really work.